The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. I'll ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call the 11 o'clock docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Tuesday, February 1st, 2022 consists of one case, appeal number 123419, State of Kansas versus Dion Jamal Greene, Geary County, briefs both sides. Your Honor, the appellant Dion Greene has reserved 2 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, Deborah Wilson, Capital and Conflicts Appellate Defender, appears on behalf of the defendant appellant Dion Greene, ready for argument.
May it please the court, Assistant Solicitor General Curtis Wired, appearing on behalf of the state of Kansas, present for argument.
Thank you, counsel. Ms. Wilson, I show that you've requested 2 minutes of rebuttal time. You may begin your argument.
Thank you, Your Honor. May it please the court, Deborah Wilson on behalf of the defendant appellant Dion Greene. This is a direct appeal from a sentencing proceeding. Mr. Greene pleaded guilty to 2 counts of first-degree murder, and he was sentenced to consecutive hard 25 life sentences. He appeals those sentences on the grounds that the trial court abused its discretion when it based its decision to impose the sentences consecutively rather than concurrently on unreliable information or an error of fact. What makes this case interesting is this unreliable information or error of fact was introduced into the prosecution by Mr. Greene himself. Mr. Greene confessed to shooting and killing Jenna Schaefer, who, unknown to him, was a few weeks pregnant at the time. Mr. Greene, during his confession, originally told the police that he killed Ms. Schaefer on an impulse or sort of on the spur of the moment. But then he quickly changed his story during the confession, and he told the police that he did it for money, that he was in fact a hired killer. And at first, the police and the prosecutors believed Mr. Greene. The prosecution charged him with capital murder based on a contract killing theory for Ms. Schaefer's death. And the police arrested 2 other individuals. One, Marshawn Baker, who Mr. Greene identified by name during his confession, and Joseph Grubb, who was not identified by name during the confession. And they were both charged in connection with Ms. Schaefer's murder as well. However, after investigating Mr. Greene's murder for hire claims, the state dropped the charges against Mr. Grubb and Mr. Baker and released both of those gentlemen. The state also dropped the contract murder allegation that it had originally made against Mr. Greene and replaced that allegation in the first amended complaint with an allegation of first-degree premeditated murder for Ms. Schaefer's death. I'd like to stress that this decision to drop the murder for hire claim was made and carried out before the preliminary hearing, and it was a unilateral action on the part of the state, not the result of a plea agreement with the defense. So after the preliminary hearing, Mr. Greene was bound over on murder, not capital murder charges.
Can you back up here a little bit in terms of the evidence of preliminary hearing and then also the proffered statement at the plea? Wasn't there evidence at the preliminary hearing that this was a murder for hire, that there was monetary consideration given to your client? Wasn't there evidence of that at the preliminary hearing?
Only out of Mr. Greene's mouth.
All
and
right.
Only
Why isn't
in
that
the
evidence?
context of the confession that was offered. But the state was not proceeding on a contract killing or murder for hire claim at that point.
And then at the plea, wasn't there also part of the colloquy to the court for the factual basis that satisfies the elements of the crime, also that evidence introduced?
Not from the state. Once again, very interestingly, only from Mr. Greene himself. And let's remember what Mr. Greene said. Mr. Greene said, "I did this for money, but nobody believes me." Nobody believes me. And that seems to be the case based on the charging history and what happened to Mr. Grubb and Mr. Baker. That appears to be accurate. In other words, the prosecution found that these statements about the contract killing were unreliable. They weren't supported by competent evidence. They weren't grounds for charges against these two men that he had named, kind of drug into this thing. And these statements weren't even grounds for charges against Mr. Greene. The state didn't believe Mr. Greene's story that he'd killed Miss Schaefer for money, or the state didn't believe it to be provable, even though Mr. Greene had advanced this version of events. Therefore, at sentencing, the state shouldn't have offered this murder for hire scenario as grounds for consecutive sentences. The state should not have led the trial court into the error of relying on Mr. Greene's rejected claims as grounds for consecutive sentences. And of course, that's what the record shows. I'll paraphrase the court a little bit. The court told Mr. Greene, anyone that thinks a human life is worth $1,000 and is willing to take that to shoot someone doesn't deserve compassion from me. It's clear to me what the sentence must be. Murder for hire is the worst thing, and it's heartless, for lack of a better word. Now, I have to apologize to the court for an inaccurate statement that I made in my brief. I was going to argue to the court today that, in fact, although the state argued vigorously for consecutive sentences, the state didn't base its argument on a murder for hire theory. However, the Assistant Solicitor General did correct me, pointing out in its brief that the prosecutor did say, after arguing, impose consecutive sentences because Mr. Greene lied throughout this confession, impose consecutive sentences because he made derogatory comments about the victim in this case. The prosecutor did say there was no concern that he had murdered this girl in exchange for $1,000. Of course, I believe the accurate statement in this case would have been, we investigated this claim and we found no credible evidence that he had murdered this girl in exchange for $1,000. I do apologize for the oversight on my part. And of course, that does change my view of the state's actions in this case. I had planned to hold up the prosecution as a paragon of virtue and note that the state rightfully didn't put forward any theory that the state didn't believe was supported by the evidence, as demonstrated by the state's charging decisions, i.e. first, oh, this is a contract killing, then later, no, this is not a contract killing, and we're not proceeding on that theory. Instead, the state did briefly reassert this theory of a crime, contract killing, that it had rejected and abandoned on its own long before the plea, long before the sentencing, because it didn't have adequate evidence to go forward under this theory. So I see how...
I'm sorry to interrupt you, but can a contract killing satisfy the elements of first-degree premeditated murder?
Yes.
So what can we really
because
discern?
You'd have intentional, go ahead.
So I guess my question is, what can we really discern from the charging decisions of the state?
We can discern they didn't have evidence to go forward on the claim, because what we have here, not only do we have the state at the beginning, assuming that it is a contract killing, and going forward with arresting other individuals, we have the state releasing those individuals without charge, and we have the state dropping on its own the contract murder allegation against Mr. Greene. I don't see any other reasonable explanation for dropping this other than they didn't think it was provable. They didn't think it would be appropriate to go forward. And let's look at what we do have against Mr. Greene. The state did have a good murder case against Mr. Greene. They had circumstantial evidence implicating him in the murder before they interviewed him. Mr. Greene led them to the murder weapon, and Mr. Greene confessed to the killing. And of course, he made those murder for hire statements during the confession. The state built its murder case on this, but then unilaterally dropped any contract murder allegations, much it seems to Mr. Greene's chagrin. I asked myself, is this some sort of exercise in prosecutorial discretion where they're thinking, well, instead of one capital murder charge, let's get 2 first-degree pre-murder charges out of this? But that doesn't work because they already had 2 first-degree murder charges in this scenario.
Counsel,
And
the bulk of your argument, at least as I understand it, has been focused on what the state did
mhm.
here. I guess I'm having a hard time connecting the dots to why that matters. Why does what the state did matter at all, given our standard of review and what the district court did?
Standard of review, of course, is abuse of discretion. An abuse of discretion can be based on a mistake of fact. And we allege in this case that the mistake of fact is the trial court's misapprehension that this was a murder for hire.
So let me summarize it differently and see if you agree. It seems to me your argument is that the district court was not permitted to believe your client because of actions that the state took. And that's what I don't understand.
In these circumstances, I think maybe if the district court had on its own said, oh, wait, didn't I hear something about a murder for hire? I'm imposing consecutive sentences based on my idea that this is a murder for hire. But remember, after dropping these allegations, after releasing the other 2 gentlemen, after not pursuing the contract murder claim at all, the prosecution brought it up in sentencing. I mean, it appears that the state didn't believe Mr. Greene's claims until it could be advanced.
No, I guess I'll just say it one more time. Why does what the state believed matter? Why aren't we looking at whether what the judge found was supported by evidence?
Because it's not supported by the weight of the evidence. Sure, we have Mr. Greene's statement, I did it for money, but all the other evidence in this proceeding is to the contrary. And I've asked myself, why on earth would Miss?
Haven't we said multiple times that a defendant's statements on his or her own behalf are always sufficient to support a factual finding? In other words, you're asking us to rule that the district court judge based its decision on a mistake of fact.
Yes.
And to get there, it would seem to me you would have to show that that fact finding was not supported by evidence.
Right. And Mr. Greene's statement, I don't believe, is sufficient evidence to support this finding. And I've asked myself, why on earth would Mr. Greene say this if it wasn't true? The record doesn't give us a positive answer as to why, but it gives us a very big clue. At his sentencing proceeding, Mr. Greene told the court that he was taking the medication Seroquel, which is used to treat schizophrenia, bipolar disorder, and depression. I can't represent to the court today that Mr. Greene is suffering from schizophrenia. I can only represent to the court that he has been prescribed medication that is used to treat schizophrenia. I think it would be a violation of due process, and also the confidence that the public places in the court should it appear that a criminal sentence was based on statements made by a schizophrenic individual, which apparently the state didn't credit as reflected in its charging decisions, both against Mr. Greene and against these poor gentlemen that he drug into this story. So we would ask that the court remand this case and give the trial court an opportunity to sentence Mr. Greene based on reliable information rather than a misapprehension of the facts.
Any other questions? Thank you, Ms. Wilson. Mr. Wired?
May it please the court. Your honors, I just want to jump off there at the last mention there, the words due process popped up, and I want to emphasize that this case is not a due process challenge. It's raised as an abuse of discretion on an error of fact. And to Justice Stiegel's question on this matter, we don't look at the state's actions in this matter, that the question is whether the district court had substantial competent evidence in the record to make this finding that Greene killed Ms. Schaefer for $1,000. We laid those facts out in the brief and just highly summarized there. Sergeant Brown testified at the preliminary hearing and the Jackson v. Dino hearing that in the interview he had killed Ms. Schaefer for $1,000. During the plea hearing, the judge asked Greene why he did it. And he said, quote, "I did it because I was paid to do it." Now, of course, the argument from the other side is that all of this evidence is coming from his mouth and he's lying. So this is probably false is the phrase they use, which I take to mean materially untrue under Townsend v. Burke. However, there's other evidence I'd like to direct this court's attention to in the record that didn't come out of Mr. Greene's mouth. One is that during the Jackson v. Dino hearing, Sergeant Brown testified that he learned $1,000 was deposited into Greene's jail bank account on December 26th, and Greene's girlfriend and or wife had received some of the money before the state was able to shut down the account. In addition to this evidence beyond Greene's statements, we have on October 28th, 2019, the defendant filed a motion to return property. And while that motion is not in the record on appeal, the discussion at the Jackson v. Dino hearing, record 6-113, makes it clear that this motion was for a portion of the proceeds that were deposited in Mr. Greene's account. So here we have evidence entirely separate from statements Greene made to law enforcement or a judge that corroborate the fact that this killing was done for $1,000. Of course, they make much of the fact that the state did not bring capital murder charges against the other alleged co-conspirators to this murder. However, as this court knows, the level of evidence needed for obtaining a capital murder conviction and comparing that to the evidence needed for a judge to make a determination during a sentencing proceeding, there's an enormous gulf there. And so what we're left with is, by the appellant, speculation about state's actions, why they did or did not take certain actions below, speculation about why of Mr. Greene's state of mind based on medication he was taking. So all in all, this evidence that we've listed in our brief and the additional evidence that I mentioned here today should lead the court to easily conclude that there was substantial competent evidence for the court to conclude that this murder was for hire and that it justified imposing consecutive hard 25 life sentences. Unless there are any questions about that issue, I prepare to stand on our brief on the second issue as well.
Questions? Okay, thank you, Mr. Wired. Ms. Wilson, your reserved time for rebuttal.
Thank you, Your Honor. I would point out that the due process claim was raised beginning on page 7 of Mr. Greene's brief. Also, I would just like to note that this is a little bit like the state charging a second-degree murder against a defendant, then reducing it to involuntary manslaughter, and then asking for an upward departure because there's some evidence that it was really first degree. This for the state to take these inconsistent positions does not seem appropriate and to comport with due process and everyone's expectation that the state will treat all people in the courts with fairness and equity, even criminal defendants.
Any other questions from the court? Anything else, Ms. Wilson?
No, Your Honor.
All right. Thank you to both counsel for your arguments in this matter. We will take the appeal under advisement. The court is now in recess until 9 a.m. tomorrow morning.